rise. The Court of Appeals Division 1 is now in session.
Good morning. Thank you. You may be seated. We're here this morning in case number CACV140819, Colony Insurance Company versus Estate of Lakeisha Anderson. These proceedings are being audio and video recorded, so we would ask when you approach the podium or begin your argument that you identify yourself and your client. Each side will have 20 minutes. Counsel for appellant, you're responsible for reserving any time that you wish to reserve for rebuttal. We have read the briefs in this matter, and we've had a conference already this morning and discussed the case. And with that, we look forward to your argument.
Thank you. May it please the court, my name is Frederick Taylor. I'm here on behalf of the appellants, Estate of Lakeisha Anderson and Gloria Johnson, representing their position that the 2008 Colony Insurance policy should cover the claim underlying the May 2012 judgment entered against its insured Palmview group home, that judgment that found Palmview negligent in its care of a developmentally disabled young woman who was placed in the group home's care through its contract with the state of Arizona to offer group home services, wherein she subsequently died while in their care. It appears that there are basically three issues that are key in determining Colony's liability, and they're kind of interrelated, but first one is, was there a binding binder contract for an occurrence form policy entered into between Colony, the insurer, and the insured Palmview group home? Two, did the surplus lines broker, Burns and Wilcox, act as an agent of the non-Arizona licensed insurer Colony for purposes of transferring a copy of the actual formal policy to Palmview, the insured? And three, did Colony issue the policy prior to the lost date of September 14, 2008, and was it required to provide adequate notice that it changed a key provision of the policy term from the binder policy to the formal policy prior to the date of loss of September 14, 2008. The trial court focused its analysis on the policy issuance issue, so I'd like to begin there with beginning with an overview of the key facts. Palmview was required by the state to have a liability policy with certain features, including occurrence form coverage. It had previously had such a policy when it approached CSI Insurance, its insurance broker, whose agent was Henry Cooper, asking to procure a new policy, and CSI found it necessary to procure that policy through an unlicensed insurer, wherein state law required that they pursue that through a surplus lines broker, in this case Burns and Wilcox. They submitted an application to Burns and Wilcox that included a disclosure of this prior occurrence form coverage, and that they were seeking an occurrence form coverage policy. Initially, Burns and Wilcox produced two quotes, one of which did not designate on the front page whether it was occurrence or claims form coverage, and the other indicated it was occurrence coverage. Subsequently, Burns and Wilcox issued a binder contract describing coverage from Colony as an occurrence form policy with apparently a binder summarization from Colony attached. So the first question, assuming that the occurrence form binder wasn't in effect, did Colony timely issue a formal policy under ARS 20-1120B that supersedes the binder terms by having emailed a copy of that policy to Burns and Wilcox. On the one hand, we recognize that case law suggests that there is a distinction between the issuance and delivery of a policy. But on the other hand, and the trial court agreed, the issuance is not simply accomplished by collecting together policy terms and at that point stating that the policy is issued. And if, from a practical standpoint, if that was the standard, then we'd have a hard time of determining when a policy is actually brought together. Nothing else, because the signature page even on them is just a form, printed form that they throw in there. But I think more importantly is the consideration that since there is no statutory definition of the term issuance, I believe the term should be interpreted in compliance with plain word meaning, in which case the plain word meaning of issuance would be the incorporate the sending out of the policy. And we'll agree that
Are you assuming that who sends it out?
when the
Burns and Wilcox, or
yes, in this case,
does that assume then that Burns and Wilcox is Colony's agent?
yes.
And what's your best argument for why Burns and Wilcox is necessarily Colony's agent?
Because everything that happened was done through Burns and Wilcox. All communications from the insured and the insured's agent CSI to Colony went through Burns and Wilcox. All of Colony's communications went through Burns and Wilcox
Why
back.
does that necessarily make them their agent if you have if the insured works through someone else, and let's say is an agent acting on behalf of the insured, there's an agency relationship there, and they're the ones who are going to communicate with potential insurance companies. But does that create an agency relationship between all of these potential insurance agencies and the broker?
Well, the broker basically left it to Burns and Wilcox to issue a quote on its form. It issued the binder on the Burns and Wilcox form. Burns and Wilcox collected the premiums. Again, all the communication. The Colony acted as if they couldn't even talk to CSI or the insured. Everything was directed through there. I think when you include the
Let's say they're acting through an attorney, and the attorney's making calls on their behalf. Usually who's ever working with them would make those calls to that person's attorney. That doesn't necessarily make that attorney the insurance company's agent.
Well, if you assume that there was an attorney for attorney for the insured and an attorney for the insurer, I think that the attorney for the insurer would be the insurer's agent. And that's kind of what we're looking at here. Burns and Wilcox took all the actions that Colony would have normally taken. Colony kind of sat in the background and called the shots, but Burns and Wilcox was the active agent in all this. And I think that's backed up by the state insurance company regulations that I cited in the reply that basically require Colony as an unlicensed insurer to enter into an alliance with Burns and Wilcox in order to write insurance in this state. But if the court disagrees with that analysis, the fallback position is that when there's terms in the binder that are contradicted by the policy that's ultimately issued, the issuance issue goes out the window in the sense that then it becomes more of a standard contract issue, wherein the insured must have notice of this change and must accept it. And even in the cases that talk about issuance simply being the sending out of the policy, they always recognize, always seem to have their eye on these basic contract concepts. And in this case, it's our position that the binder contract was an occurrence form agreement, and therefore, if Colony wanted to change that, they needed to bring that to the attention of the insured, and they never did. And the insured never even had a copy of the policy until after September 24th.
Colony was aware of what was in the correspondence from Burns and Wilcox?
I'm sorry?
Is there something in the record that shows that Colony was aware of what the cover sheet that Burns and Wilcox sent, the binder, that says it's an occurrence policy?
Well, there's certainly
Colony sent a policy that's inconsistent with that to Burns and Wilcox, right?
Colony sent a binder summarization and asked Burns and Wilcox to send out this binder. And Burns and Wilcox sent out the binder that specifically says it's occurrence coverage. There are communications back and forth where the person at Colony thanks the person at Burns and Wilcox for binding it or sending them the bind and what have you. They certainly knew something was sent out. Now, whether they actually looked at what Burns and Wilcox sent to the insured, it's not clear. I would suggest that maybe that was their responsibility to have overseen that communication, made sure that everything was done properly.
So is your argument based on the binder agreement itself, or is it B&W's statement on the cover letter that went with the binder agreement that is the basis of your argument?
Our argument is that the Burns and Wilcox document that's called a binder agreement, and in its first line says this is a binder contract for insurance, is the binding contract at that point in time.
Even though the actual binder agreement that came from Colony was claims made in occurrence contract, right? Is that
well?
So your argument, and correct me if I'm mistaking it. Your argument is that the statement in the letter on top of the binder agreement is part of the binder agreement, so that stands.
Well, I would think that if I was an insured and looked at a document that said binder contract, and the first sentence said this is a binder insurance agreement, my inclination would be that, yes, this is the binder insurance contract, and if there was something attached called a summary that further references some, in very vague terms, some forms and endorsements that also apply, I would be inclined, I think, as a reasonable person, to look at that front page and say, okay, binder contract, occurrence policy in big capital letters. I'm good to go as far as that aspect of my coverage.
Even though if I had read the agreement itself, I would understand it's not occurrence, it's claims-based?
Well, I guess I would question whether reading all the documents together clarifies that issue. Again, you see occurrence in big letters. The second, this binder summarization does in small print say form, as far as the form of the policy, that it is claims made policy. But it's just not clear that this summarization supersedes the actual binder contract. And that brings you into the realm of reasonable expectations. Keep in mind that Palmview applied for an occurrence policy. It made it then, and Gadwavamba, the manager for Palmview in the deposition, made it very clear on numerous occasions that he needed to have the state requirements, which in the policy, which included an occurrence policy, and the state contract makes that clear that occurrence coverage is needed. So as someone who applied for an occurrence policy and gets these indications that an occurrence policy was issued, I think reasonable expectations would be that that was the coverage that they had.
If you were representing Palmview, I understand your argument with precision, but you're not.
No.
So what's your best case for the thought that reasonable expectations apply with that degree of force in this sort of third-party context?
Well, I think I cited a case that states that the third party can rely on the reasonable expectations of the insured in applying that doctrine. The exact case I don't have in front of me, but I believe it's in my brief.
Okay.
I would like to reserve unless there's other questions right now, I'd like to reserve the final 5 minutes.
One follow-up on
Sure.
that, though. The reasonable expectation for a third party would be through the first party's reasonable expectations? In essence, is a third party beneficiary kind of? Is that?
Yes, Your Honor, and that's my understanding of what the case holds.
Okay. Thank you.
Good morning. May it please the Court. Thomas Crouch for Colony Insurance. I want to direct the Court's attention to the actual paper that we're talking about. If you have Appellee's brief handy, either in paper or iPads. I don't know if anybody's an iPad user up there. The quote we're talking about, and let me just back up for 1 second. We have my client, Colony, issuing a quote for claims made coverage. The quote being essentially a 2-page document, and on the very first page, and that's 62, it says form claims made. The second page has a list of forms that would be part of the insurance policy. This is typically how it's done. You give a quote, here's some numbers, cost, premium, and then here's the forms that are going to be part of the policy. And the second page, the very first form listed, shows claims made coverage. They were asked to bind coverage. They issued a binder. Those are a couple pages later, 68 of Appellee's appendix. And you're going to notice that it looks very similar, virtually identical to the quote. The same thing, it refers to claims made as the form, and then the next page has the forms that are going to, the policy is going to comprise, and the first one listed, of course, is claims made coverage. They then issued the policy, and we'll talk in a moment about issuance versus delivery. And when they issued the policy, they issued a claims made policy, and it contains the forms identified in the quote and in the binder, and the policy itself very plainly says claims made. Now, what happened along the interim where this word occurrence shows up? If you go to page 64 of Appellee's appendix, you'll see that what we refer to it as a cover page from Burns and Wilcox, which is the surplus lines broker who is procuring insurance on behalf of the insured. Those are not my words, those are the statute's words that describe in Arizona what a surplus lines broker is. And that's the insurance department's words. When you go on their website and say, what is a surplus lines broker? It's a broker acting on behalf of the insured to procure insurance coverage. But if you go to the summary on page 64, you will see it's describing the quote, and it's referring to as per the attached company quote. And there's several places where it specifically says that. That document, if you look at it and kind of peruse it for a few minutes later, I suppose, you won't see occurrence on there. Okay? There's no reference to occurrence. It's as per the company quote, and the company quote says claims made coverage. Now flip to the next page, which is 65. And I think my colleague made a mistake in saying that the other quote that was procured from a different carrier, the Lloyd's quote, didn't mention claims made. Well, in fact, it does. Their quote, likewise, shown on page 65 of our appendix, refers to claims made coverage. So certain underwriters at Lloyd's also provided a quote for that type of coverage. And it, too, the second page of it, has its forms. Now, flip to the next page, page 67. And that is we call it a summary that Burns & Wilcox prepares when it delivers the quotes it's obtaining from the marketplace to CSI, which is the non-surplus lines broker that Palmview used to procure its insurance coverage. And you'll notice it looks kind of like the same piece of paper we just looked at a few pages earlier from Burns & Wilcox, and it has that word occurrence there. Now, it's not presenting a occurrence quote. It's presenting the as per attached quote from underwriters at Lloyd's, which was claims made coverage. I don't know why that word popped up there, but it did. The next page, 68, is the binder that Colony issued when it received a request from the insured to bind coverage that it had quoted. And that binder, likewise, refers to claims made coverage. It's right there, dead center in the form on page 68. Form, claims made. Very first line on the next page of the coverage form, claims made. If you flip to page 70, that's where the word occurrence pops up. And and again, this is that kind of summary page that Burns & Wilcox prepares and submits to CSI with the originally the quote from each of the two carriers, and now the binder that coverage has been bound because the insured requested it. And that too, it says, as per company binder that's attached, says it in several places, as per attached company binder, under exclusions, endorsements, conditions, etc. And of course, the binder, as I just mentioned, spelled out that it's claims made coverage.
Are there any circumstances under which someone like Burns & Wilcox could be viewed to be an agent of the insurance company? Is there statutory prohibition, or is it permissive under the statute? Can they be an agent of the insurance company?
They could be if they entered an agreement and the carrier provided binding authority. Carriers enter agreements with brokers, sometimes surplus lines brokers, that gives them that authority, but that didn't exist here. Matter of fact, we know that because Burns & Wilcox had to specifically request that Colony bind coverage. That demonstrates they didn't have that authority.
If I hear you right, then the only type of agency that could obtain here would be actual, not apparent
That's correct.
agency. And why is that?
Because we don't have any facts, first of all, that would support a apparent authority.
Let me follow up, though, on Judge Catani's question that I think was more global than that, and you responded with an actual agency. But are you saying there couldn't ever be facts that would support an apparent agency in this context?
There aren't any in this case. If you're asking me, could we come up with hypotheticals, I suppose
That's exactly what I'm asking. If in other words, you're not saying, are you, that only actual agency could obtain, that there could be a world, could be facts, where apparent agency would apply, just not this case?
True.
Okay, thank you.
Maybe, for example, if the broker is soliciting on behalf of the insurance company as opposed to making a solicitation on behalf of the insured.
Right, and I think
in which there might be a...
And I think you're alluding to the fact that in this particular case, Burns & Wilcox was acting on behalf of the insured to go out to the marketplace from various resources, carriers, and soliciting quotes, as opposed to a carrier having an agent that goes and tries to sell a product to a particular insured. And I want to, I have a lot of points I could make, but I suppose on the reasonable expectations reference we have, keep in mind that the evidence is undisputed that none of these documents, either the binder or the summary pages prepared by Burns and Wilcox, was ever seen by the insured.
And
the
let
evidence
me
is
ask,
undisputed.
and Al, you heard me ask the appellant the same question. Does that sort of third-party world just chop reasonable expectations off at the knees?
Let me answer that question this way. There isn't a prohibition, if you will, from somebody other than the insured standing in their shoes and asserting a reasonable expectations argument. Okay, but a third-party claimant's expectations are irrelevant. That third party would still have to present proof, the same proof the insured would have to submit in order to invoke the doctrine. And my whole point here is I'm not urging this court to reject the reasonable expectations doctrine because of the party who's making it. I'm urging the court to reject that because there's simply a complete absence of any evidence on those four factors that must be presented. We don't have any obscure, strange provision of a policy that can't be understood by a reasonable insured. We don't have a hidden provision that was unexpected. It's claims-made coverage. The insured received the policy, acknowledged, excuse me for a moment, got to wet the whistle. The insured acknowledged receiving, and I'm talking about Mr. Wavumba, acknowledged receiving the policy. None of those other documents, just the policy, reviewing it. He could see in the first few pages it was claims-made coverage. There was never any objection. Hey, wait a minute. This wasn't what I expected. None of that evidence exists. And, of course, there's no conduct on the part of Colony, attributable to Colony, that gave either a reasonable insured the objective understanding that there would be something other than claims-made coverage or this particular one.
Do other states not have the occurrence requirement? If it's required under, I don't think there's a dispute that the contract that was issued wasn't, that Palmview was required to have occurrence coverage and didn't comply with that requirement. Do other states not have that?
Actually, let me refer you to page 158 of Appellant's Appendix, because that's one page of the huge requirements that are imposed as contractual obligations by somebody in Palmview's position performing services with the state. And that heading down at the bottom refers to professional liability coverage, and it says, if the professional liability coverage is provided on a claims-made basis, then blah, blah, blah. Well, that demonstrates that professional liability coverage can be provided on a claims-made basis. And so there's this suggestion that they couldn't go out, they had to get occurrence coverage under that contract. For professional liability coverage, which is what we're talking about here, that coverage is almost always written on a claims-made basis anyway. So did that answer your question?
Yes.
I'm going to I have quite a bit of time left, but I'm sure you won't mind if I don't take it all. The last point I want to make is really the reason that the trial judge rejected this binder contract argument is that indeed under Arizona statutes a binder is no longer valid upon issuance of the policy. And in this case, it's undisputed that the policy was issued no later than September 12th, because that's when the physical policy was delivered to the Burns and Wilcox surplus lines broker. Incidentally, if you You know how you think you know your case inside and out, and then you're preparing for oral argument, and you see something. Well, I saw something. If you look at page 73 of our appendix, that's the policy declarations page, and I don't know how it's possible that this is the first time I ever noticed it, but it actually has right dead in the center. It says issued 9/9/2008, 9/9 September 9th, 2008. And of course, on the 12th, it's sent to Burns and Wilcox. The trial court just simply said, well, by the 12th, it's obviously issued. And that's before the unfortunate event on either the evening of 14th or 15th of September. So as of the time of the 14th or 15th, the policy is what controls the coverage here. Because under statute, the binder was no longer valid. And that was the basis for the trial court's ruling on that issue.
And that would be true even if the policy was completely different than the binder?
Which it wasn't, but that's true.
So
yes.
no matter
Under
what,
statute.
you could sort of say, yes, this was occurrence, and then issue a claims made, and too bad, so sad.
The policy would control. But of course, I'm not, for
I
a
understand
moment,
you're not conceding that.
acknowledge that was the case.
And wouldn't that open other claims too, like material misrepresentations, things like that, if there was such a disconnect between a binder and a contract?
I suppose I wouldn't be shocked if somebody tried to come up with a clever claim to that effect, but of course, we don't have those facts here.
Well, and I understand that, but if I go down and buy a car and I enter into a purchase contract and for a fancy car, and I get a non-fancy car, it seems to me the law might give me more tools in my toolbox to correct that than saying, well, the statute says, the contract said you bought this.
True, although, I mean, we're talking about contract law here. There's doctrines such as merger and that sort of thing.
And fraudulent inducement, too, I suppose, too.
There is. I mean, there's all kinds of doctrines, but those were never argued here, and there's simply no
And I understand
basis.
your position is we don't get there for a couple of reasons. One is the binder was consistent from your perspective with the contract of insurance, and second, those claims were not made, and the facts would not support those claims if made.
I'll summarize by saying that this case simply presents an example of what happens when an insured doesn't maintain continuous coverage. The outcome is unfortunate here for the claimant who had a claim against the insured, but the fault lies with the fact that the insured didn't maintain continuous coverage, and that's why the outcome is what the outcome is. I'm asking for affirmance. Thank you, Your Honor.
Thank you. To follow up on a question Judge Thuma presented, the case I was thinking of was Beaver versus American Family Insurance and Colon, which talks about a third-party beneficiary being able to rely on the reasonable expectations of the insured. And also I'd like to make a correction on the representation of the insurance binder and the attached documents. Appellee represents that the medical binder confirmation from Colony was the leading document. I think it's clear in the evidence that Burns and Wilcox's insurance binder was the first page, and that it makes reference to attached documents, which I assume were the allied medical binder confirmation, where, yes, in small print it does say claims made, whereas on the first page, top of the page, in the large print it says an occurrence form policy. And that's what I would suggest an insured or anyone looking at this binder would focus on, particularly if that was the type of coverage that they were seeking. And similar representation on the quotes. The initial pages of the quotes were the Burns and Wilcox forms, and indeed one of those quotes does say commercial general liability occurrence on its front page, again at the top in very large letters. And so far as the issue on agency, I believe that, and I did cite that in appellant's brief about apparent authority being applicable here, and case law basically saying that when a principal does things that lead a third party to believe that this agent has authority, that can be deemed apparent authority, and therefore the principal agent relationship exists.
Do you agree that there's a difference when an agent is acting on behalf of the insured as opposed to when, say, an insurance company sends an agent out to solicit business? Or in your view, is this agent always acting on behalf of the insured?
No, and I think the case law is clear that an agent, broker, can wear different hats at different times. And like I said, in this case, not to go over them all again, all the correspondence was through Burns and Wilcox.
But all of it was initiated by the insured. Initially, the request for coverage.
Yeah, and then the insurer, and coming back to the insured, always went through Burns and Wilcox. Like I said, the premium was paid to Burns and Wilcox and then forwarded to the insured. I mean, again, Colony, there was nothing keeping from Colony from directly communicating with CSI, but they chose to go through Burns and Wilcox and made it presented Burns and Wilcox as the face of the company, basically.
But that's the only the best evidence that you have then is the correspondence from Burns and Wilcox. There's nothing else that you're suggesting that Colony had specific knowledge of something. There's no other evidence other than the correspondence from Burns and Wilcox. Is that right?
Well, yeah, the correspondence, the payment, the issuance of the policy. I mean, it's almost by Colony being neglectful and not following up or reviewing what Burns and Wilcox was sending out, I don't think that lets them off the hook. I think that they just gave Burns and Wilcox their responsibility of making sure they review what goes out to an insured so that a situation like this doesn't happen.
Okay, I think your time's up. Thank you both for your argument. We'll take this matter under advisement and issue a decision in due course.
Thank you.
We'll stand in recess.